Hi, here at Cornerstone Legal we specialise in land compensation. Land compensation is a complex area of law. Firstly, you may have received a notice of intention to take, which is registered with the Department of Land Information, indicating that your land is required for the purposes of a public work. When you receive a notice of intention to take, you are entitled to make an objection to your land being taken by the government to the Minister. The Minister will then consider any objections received. After having considered any objection received, you receive notice whether or not your objection is upheld or whether your objection is dismissed. You really should only object if you consider that your land is not properly required for the purposes of the public work. After the Minister has considered all of the objections, the Minister will then consider whether or not to issue a notice of taking. The notice of taking is registered with the Department of Land Information. A notice of taking can only be issued if your land is required for the purposes of a public work. This occurs by a taking order being registered over your land with the Department of Land Information. Through that process, your land is taken from you and the government then comes back into the ownership of your land. You are then entitled to make a claim for compensation. A claim for compensation is made under the provisions of the Land Administration Act. Section 241 of the Land Administration Act sets out the various heads of claim. Firstly, you're entitled to make a claim under Section 2412 of the Land Administration Act, which entitles you to the value of the land, disregarding any increase or decrease caused by the proposed public work. I'll come to that in a moment. Secondly, you're entitled to disturbance. What that means is any costs, for example, for moving, or any other costs thrown away, for example, planning costs that you may have incurred for the development of the land, or any other costs which are reasonably incurred by you before the land was the subject of the taking or the notice of intention to take was registered over your land. Next, you're entitled to a claim for compensation for the damage to the value of the adjacent land or adjoining land. That means that you're entitled to a value associated with the reduction caused by the public work to the land immediately adjacent to the land the subject of the taking. Next, you're also entitled to interest, backdated to the date on which you have made the claim or the date on which your land is first entered for the purposes of the public work. Here at Cornerstone Legal, we're able to assist you to make your claim. It is very important that you make a claim as soon as possible after the registration of a taking order. Interest begins to run immediately. You have 6 months within which to make a claim, and it is not necessary to receive your valuation evidence prior to making a claim, even though this may be helpful in order to ensure that you properly identify the value of the land taken, disturbance value, injurious affection or severance, and any other head of claim which you may have entitlement to.